Welcome to Better Call Sam, the legal podcast brought to you by Sam Perry, attorney at law of Perry Law Offices. On this show, we take calls from listeners and tackle their real life legal questions, breaking down the law in plain English. Today's episode is titled Will They, Won't They? All about the importance of wills and trusts. These aren't just for the wealthy, they're for anyone who wants to protect their family, ensure their wishes are honored, and avoid costly disputes. A will makes sure your intentions are clear, while trust can provide added privacy, flexibility, and long term security. Together, they're the key to planning wisely and leaving behind peace of mind. Now, let's go to our listeners and see what they have to say. Caller one, you're on the air.
Hey, Sam. This is Russell from Lancaster, South Carolina. Longtime listener and excited to be on the show. I got a few questions about wills and probates here in South Carolina. First, what happens if I die without a will?
Great question. If you pass away without a will in South Carolina, the state decides who gets your property through what's called intestacy law. Here's how it works. If you're married with kids, your spouse gets half and your children share the other half. If you're not married but have children, they inherit everything. If you don't have a spouse or children, then it goes to your parents, or if they're no longer living, to your siblings. So having a will is the key if you want to control over how your assets are divided.
So I need a lawyer to make a will in South Carolina?
No, you're not legally required to hire a lawyer. You could draft one yourself, but here's the catch. Wills written without legal help are often incomplete, invalid, or don't actually achieve what the person wanted. That's why I always recommend talking with an attorney. It's not just about the paperwork, it's about making sure your plan works in practice.
Well, how long does probate of an estate usually take here?
In South Carolina, the probate process has to stay open long enough to give creditors a chance to make claims. That's usually the shorter of 8 months after publishing a notice to creditors or 1 year from the date of death. At a minimum, you're looking at about a year for the estate to be wrapped up. But it can take longer depending on the complexity of the issue or if family members start fighting over things.
So I have to open an estate for my wife who passed?
It depends. Probate is only required if the probate assets, things that don't automatically pass to someone else. For example, if all assets have beneficiary designations or rights of survivorship, you may not need to probate. But most people have at least one probate asset. If the estate is worth less than $25,000, then there's no real property. You may be able to use a small estate affidavit instead of opening a full estate. If there's more than that, or any real estate, you'll have to open a regular estate in probate court.
All right, last one. Does a will have to be filed with the court in South Carolina?
Yes. In South Carolina, a will must be filed with the probate court within 30 days of the person's death. It doesn't need to be filed before someone else passes. But after death, it's required, even if the will doesn't end up being probated. Russell, I want to thank you for bringing those questions. They're exactly the kind of concerns people have, and they show why planning ahead with a will or trust makes such a difference. Now let's keep it rolling. Caller two, you're on the air.
Hey there, Sam. This is Rudy from Charlotte, North Carolina. A long-time listener, and I'm really excited to be on the show today. Now, what exactly is the probate here in Charlotte?
Probate court in Charlotte. Probate court in Charlotte and across North Carolina is the process that handles the formal steps of settling someone's estate after they pass away. The purpose is to make sure debts are paid and assets are distributed fairly under the law. But probate can also be expensive, time consuming, and can delay your loved one's access to assets you intended for them. That's why a lot of people here in North Carolina try to plan their estates in a way that avoids or limits probate. Perry Law Offices, that's one of our top priorities, helping clients bypass probate whenever possible.
Whoa! So, what exactly is the probate process here in North Carolina?
Now, every case looks different, but the framework is fairly rigid. Generally, probate goes through 6 steps. 1. Initiating the case with the court. 2. Notifying creditors. 3. Preparing an inventory and valuation of assets. 4. Determining whether the estate qualifies as a small estate. 5. Handling any caveats or challenges to the will. And 6. Finally, setting up the estate and distributing assets. Now, even though the steps are standard, how complicated it gets depends on the assets involved and whether anyone contests the will. That's why having a lawyer to guide you through this is so important.
Well, can you tell me about setting up a living trust?
A living trust is one of the best tools to keep your assets out of probate court. Here's how it works. You transfer your assets into the trust while you're still alive and set conditions for how your heirs or beneficiaries receive it. Because the trust, not you personally, owns the assets, those items usually bypass probate entirely, and the trust takes effect immediately. So your wishes are enforceable right away.
Yeah. What about jointly held accounts and property titles?
That's another simple but powerful strategy. If you hold assets jointly with someone, like a bank account or property deed, when one owner passes, the surviving owner automatically takes full ownership. That happens outside of probate. No court involved required. Very common example is a joint bank account shared by spouses.
And finally, what kind of services do you provide as a probate attorney in Charlotte?
At Perry Law Offices, we help with all kinds of probate matters. That includes guiding someone who's been named as the administrator of a loved one's estate, contesting estate planning documents if there's fraud, or simply helping families unseal and read a loved one's last will and testament. We combine strong legal tools with a personalized approach because probate is not just about paperwork, it's about helping families through one of the hardest times in their lives. Now, I want to thank you, Rudy, for those thoughtful questions. They highlight the big differences between South Carolina and North Carolina probate and why estate planning has been tailored to the laws where you live. Well, that's all the time we've got for today's episode of Better Call Sam. We've seen how wills and trusts can make a huge difference and how probate plays out differently depending on whether you're in South Carolina or North Carolina. Remember, no matter your situation, planning ahead puts you in control and spares your loved ones from confusion and stress. Thanks again to Russell from Lancaster and Rudy from Charlotte for calling in. And thank you to all our listeners for tuning in. If you got any questions you'd like answered on the show, don't hesitate to reach out. And if you need my help, you know what to do. Better call Sam.